I knew I was in trouble the moment I saw a hand-delivered envelope pinned to my front door, the HOA logo stamped in bold red on the back. It was an early morning in late September, and I'd only lived in Willowcrest Estates for a week. The lawn was freshly mowed, the neighborhood was quiet, but my heart pounded at the sight of that accusatory notice fluttering in the breeze like a white flag of a battle I hadn't even joined yet. As I pulled the envelope down, I couldn't help but let a chuckle slip. If only they knew who I was, who they were sending these petty threats to. But that revelation, I decided, could wait. After all, they had no idea they were dealing with the very judge assigned to hear their upcoming lawsuit in district court. My new home was a charming, if somewhat old-fashioned, craftsman-style house. I'd chosen Willowcrest Estates because of its towering willow trees and winding walking paths, ideal for an evening stroll after long days on the bench. Little did I realize I was walking into the crosshairs of a notoriously overzealous homeowners association. In the past, I'd heard rumors about controlling HOAs, ones that measured the length of your grass and timed how long your car sat in the driveway. But I'd never encountered one so audacious that it would attempt to evict a homeowner over trivial matters. And so, standing on my porch, I opened the envelope and read the contents. The letter inside was addressed to me in thick, serious-looking font. Apparently, I was in violation of the HOA landscaping guidelines. My daisies, yes, daisies, were outside of the approved floral scheme. I read that line 3 times, convinced I had misunderstood. Could it be that there was some arcane color palette in place here? Did daisies not meet the aesthetic expectations of their landscape code 331? A quick scan of the letter confirmed that, yes, they took issue with the color. White was too bright and distracting, according to them, or so the letter implied. The more I read, the more incredulous I became. I shook my head and set the letter on the kitchen table, determined not to let it sour my morning. Once I arrived at the courthouse, a building with marble floors and tall windows that always felt too cold, I tried to focus on the cases of the day. My robe weighed heavily on my shoulders as I listened to testimonies, pored over evidence, and maintained order. As a judge, my entire career had been about fairness and impartiality. I gave no special treatment, nor did I expect any in my personal life. But somehow, the notion of an HOA weaponizing petty rules made me uneasy in a way more serious cases never had. Midway through the afternoon, during a recess, my clerk quietly approached me with a new docket. We had an upcoming case involving Willowcrest Estates HOA. A wave of surprise rippled through me. The same board that pinned that envelope to my door was currently embroiled in a lawsuit. It wasn't an eviction case, but a dispute over misused funds and potential harassment of other residents. It was set to appear in my court in a matter of weeks. I knew I had to walk a fine line. If the opposing party's attorney discovered that I, the presiding judge, lived in that very community, they might demand recusal. As per my ethical guidelines, I should indeed recuse myself if there was any chance that my impartiality could be questioned. Yet I wanted to see how the HOA operated. If they were already going after me for something as trifling as daisies, imagine what else they were doing to folks who didn't have the resources or patience to fight. It was a moral conundrum. Driving home that evening, I oscillated between concerns about the court rules and a flicker of mischievous satisfaction. The board had no clue I was the judge. They had no idea I possessed the power to hold them accountable for their actions, not just within Willowcrest, but in a legal sense. I parked my car and noticed my daisies swaying in the last rays of the sunset. The unwelcome letter was still on the table, waiting for me to decide whether to respond or simply disregard it. The next morning, I received an email from the HOA reminding me that non-compliance would result in a daily fine. By the following Friday, further action would be taken, possibly including forced removal of the unauthorized flowers. They ended with a firm statement. In extreme cases, the HOA board can vote to request eviction proceedings if a resident continuously violates guidelines. We trust this can be resolved amicably. Eviction over daisies? The brazen tone of the letter made my blood simmer. They were pushing me, pushing every boundary of sanity. But for now, I refused to mention my position in the judiciary. Instead, I had a different approach. Let them think I was just an unsuspecting homeowner who didn't know the first thing about codes and regulations. Let them keep rattling their sabers. In the meantime, I'd gather all the evidence I needed, both for the Daisies fiasco and for my own quiet sense of justice. Still, I wondered if I should start by attending an HOA meeting to see how they operated. I wanted to hear them justify these bizarre standards in public. So, that same day, I shot off a calm, polite email to the association's main office requesting the date of their next open meeting. The response was curt. Attendance is by prior approval only. To attend a meeting, you must fill out the standard request form. Expect to wait 2 weeks for a reply. Another barrier. Another attempt to control. If that's how they wanted to play, fine. I'd jump through their hoops for now. And so it began, my covert standoff with the Willowcrest Estates HOA. Little did they know, each unwarranted threat and each petty restriction was fueling my determination, inching us closer to an inevitable showdown. Let them come for my daisies. I'd be waiting with more than just a spade and a watering can. The following week, I had barely finished my morning coffee when I heard an aggressive knock at the door. I opened it to find a tall, gaunt man in a crisp polo embroidered with the HOA logo. Flanking him was a shorter woman with a severe bob haircut, clipboard in hand. She introduced herself as Marjorie, the board secretary, and he was Graham, the vice president. They both exuded an air of self-importance so thick it threatened to choke the hallway. "We're here about your continuing violation, Mr. Anders," Graham announced, pointing to my front flower bed with a pen. "You were advised to remove or replace the daisies with an approved color. We see no attempt to rectify the situation." Marjorie nodded vigorously. "Additionally, your garbage bin was left at the curb until 6:05 p.m. last Wednesday," she said, flipping a page on her clipboard. "The guidelines stipulate bins be returned to storage no later than 6 p.m. I almost laughed. 5 minutes? They were citing me for a 5-minute delay? But I kept my expression neutral. I apologize if I missed that exact time frame. I came home late from court. I'll keep a closer eye on the clock. Be that as it may, repeat violations signal a disregard for community standards," Graham said. His voice echoed in the foyer, with the morning sunlight made him appear almost ghostly. "We'll be issuing a formal warning. Any subsequent violations may lead to more serious consequences, including," he paused as if savoring the effect, "eviction." Marjorie handed me another bright red notice. "Please see this as your final warning." They left as abruptly as they arrived. I shut the door, my mind a swirl of annoyance and reluctant amusement. Was this truly how they thought they could govern a neighborhood? In all my years on the bench, I'd encountered less pedantic micromanagement in the strictest corporate environments. Yet here we were, discussing daisies and garbage bins as though they were capital offenses. That evening, I decided to walk around the neighborhood. Sunset cast a gentle light across manicured lawns and symmetrical flower beds. As I passed by, I noticed other types of flowers that seemed to deviate from the official palette: pale pink roses, bright red geraniums. Did the HOA even notice those? Or were they selectively enforcing rules against new residents, perhaps in search of easy fines? It wouldn't be the first time an HOA singled out outsiders. Near the community center, I saw a petite woman struggling with a stack of boxes. I hurried over to help. Her name was Ellen, a widow who'd lived there for 10 years. After we placed the boxes on a nearby bench, she sighed. "You're the new homeowner at 147, aren't you? You have the daisies out front." I braced myself, unsure if she would chide me for violating the dreaded color code. Instead, she smiled sympathetically. "I heard they're giving you a hard time. Don't let them bully you. My late husband and I faced similar nonsense years ago over a garden gnome, of all things." "A garden gnome?" I repeated, intrigued and mildly amused. She nodded. "They claimed it was an unapproved decorative item and threatened to fine us. We fought it, but they wouldn't let up until we removed it. I still have it in my garage, just waiting for the day the HOA's power trip ends." I thank her for sharing. That conversation solidified a growing suspicion. The HOA in Willowcrest wasn't just strict. They relished control, nitpicking at anything that deviated from their cookie-cutter vision. Residents like Ellen suffered in silence to avoid conflict. But as I walked back home, stepping under the low-hanging willows, my conscience wrestled with itself. A judge is supposed to be impartial. Yet I found myself drawn into these people's stories, rooting for them against an overbearing authority. It felt personal because it was personal. Those daisies in my yard symbolized the right of a homeowner to enjoy their property within reason. The next day at court, I reviewed the Willowcrest Estates lawsuit file in my office during my lunch break. The board was being sued by multiple residents who claimed the HOA had violated fair housing laws by targeting certain homeowners, particularly newcomers, widows, and individuals who had challenged the board's authority. The allegations range from illegal fines to invasion of privacy, and the plaintiffs demanded damages plus the dissolution of the current HOA leadership. If even half of the claims held water, the board was in trouble. Then came the biggest curveball. My clerk informed me that the hearing was scheduled to begin exactly 2 weeks from Friday. That meant I was officially designated as the presiding judge, a situation riddled with ethical pitfalls. According to standard procedure, if I lived within an HOA that was part of a case I was assigned to adjudicate, I should disclose the conflict or recuse myself. But I knew that if I recused, the case would be handed off to a different judge, possibly someone less inclined to see the oppressive nature of the HOA's behavior. On the other hand, staying on might raise questions about impartiality, especially if the HOA found out about my Daisy's fiasco. I took a deep breath, reflecting on the code of judicial conduct. The law demands judges maintain both the appearance and the reality of fairness. But recusal is not always mandatory if the conflict is minimal or if the judge feels they can remain unbiased. This was a tricky needle to thread. If I recuse myself too quickly, the board might keep getting away with its questionable tactics. If I stayed, I risked professional scrutiny. Eventually, I decided to keep quiet for a little while longer. I continued gathering facts, keep my ear to the ground. I wouldn't sabotage the case, but I also wouldn't let the HOA's high-handed tactics escape judicial scrutiny. It was a calculated risk, but one I believed was necessary. My plan was simple. Let them keep piling on their petty threats. Let them show their true colors. If my impartiality was compromised, I'd recuse at the last possible moment, but not before the truth came to light in the public record. That weekend, I received another notice in the mail, this one more aggressive than before. It read, "We have observed no attempt to rectify your ongoing violations. The board will meet to discuss further action, potentially including eviction proceedings, on Tuesday." They ended with an ominous line. "You are strongly advised to comply with the regulations before the meeting." I found it telling that they used the word observed. Apparently, they'd been watching my property, and by extension me. It was more than a little unsettling. But if they thought intimidation would force me to capitulate, they didn't know me at all. In my court, I'd stared down hardened criminals, corporate sharks, and cunning lawyers. A couple of power-tripping HOA board members wouldn't even make me blink. After a moment's reflection, I composed a polite letter in return, stating that I believed my flowers were within reasonable community standards and that I needed clarification on the color restrictions. I also requested they provide me with documentation of any official approvals or denials regarding daisies or similar flowers in the neighborhood. My aim was to lay a paper trail to record their every response. If they escalated, I wanted evidence in black and white that they were arbitrary, inconsistent, and targeting me for reasons beyond a simple color scheme. Tuesday night arrived like a storm. The board meeting would determine my fate, or so they claimed. But little did they suspect the bigger storm brewing. In 2 weeks, I'd be the one presiding over the legal battle that could upend their entire operation. As I went to bed that night, I couldn't help but grin at the irony of it all. A Daisy's dispute might spark a neighborhood revolution, and they had no clue that the most powerful piece in this chess game was the one they thought was a mere pawn. I awoke on Tuesday with a strange sense of excitement, like I was anticipating a verdict in a high-profile trial. Except this time, I was the defendant, and the charges were white petals and a tardy garbage bin. The board meeting was scheduled for 7 p.m. to be held in the Willow Crest Estates Community Hall, a modest building painted a subdued beige, as if color itself might offend the HOA if it were too vibrant. The email I'd received that morning stated I should arrive 5 minutes early to sign in. When I entered the hall, I found a small crowd of residents clustered in folding chairs. On a raised platform at the front sat the board members. President Bernice McAllister, stoic-faced and silver-haired. Vice President Graham, the tall, gaunt man I'd met earlier. Secretary Marjorie, with her severe bob, and 2 other members I hadn't yet encountered. A large projector screen displayed the HOA emblem. The atmosphere was tense. It felt like a tribunal more than a community gathering. I took a seat in the back row, silently noting the body language of the board. They exchanged whispers, cast furtive glances in my direction, and scribbled notes as though preparing for a grand trial. Just before the official meeting commenced, Bernice tapped the microphone. "We'll begin with old business and then move on to new violations," she announced with an air of grim authority. They discussed financial reports and maintenance concerns, breezing through budget line items with robotic efficiency. Eventually, Marjorie flipped a page in her binder and read, Item 6B, ongoing violation at 147 Elm Willow Road. Resident, Mr. Anders, continues to display unapproved flowers. Additional infractions include repeated tardiness in removing waste bins from the curb. A ripple of murmurs passed through the audience. Several neighbors cast sympathetic glances my way. Bernice smoothed her notes. "Mr. Anders, if you would kindly come forward and address the board." I walked to the front. My heart pounded, but I maintained a calm exterior. The judge in me was used to being the person behind the bench, not standing in front of it. Part of me found it almost comical, but I also recognized the stakes for everyone in this community who'd faced similar intimidation. Bernice fixed me with a stare that could slice steel. "We have provided multiple notices regarding your daisies, which do not conform to our approved plant list. Additionally, you were fined last week for failing to remove your bins on time. We must decide tonight whether to proceed with eviction recommendations." Graham chimed in. "Unless you're prepared to comply immediately, your recalcitrance leaves us no choice." I could have easily pointed out that daisies were hardly a threat to community property values, but I decided to go a step further. I opened the folder I'd brought, filled with printed emails, copies of the HOA guidelines, and pictures I'd taken of neighbors' equally non-compliant flowers. Clearing my throat, I said, "Before you make that recommendation, I'd like to present some documents. According to your own bylaws, specifically Section 12.4, any plant not explicitly prohibited is permitted. I see no mention of daisies being prohibited. In fact, I see allowances for any variety of annuals in white, pink, or red. Daisies are annuals, and they are white, so I'm not in violation." A confused look washed over Marjorie's face. She rifled through her binder. It must be a different list. Maybe Section 12.5 or 12.6. Graham frowned. "We reserve the right to disallow specific varieties we deem disruptive to the uniform appearance of the community." "Understood," I replied, "but that statement isn't in the official documents you've provided me, nor does it appear in the copy I downloaded from your website. If it exists, I'd be happy to read it. Could you direct me to that clause?" At that, Bernice cut in sharply. "We are not obliged to disclose every detail of our enforcement policies. Sometimes we must act in the best interests of the community without going through a tedious bureaucracy." Her words hung in the air, and a few residents stirred uncomfortably, whispering among themselves. Then Ellen, the widow with the garden gnome story, raised her hand. "Excuse me, but that's not how it's supposed to work. We're entitled to see every rule the board wants to enforce." Bernice glared at her, but I quickly pressed on. "Transparency matters, Ms. McAllister. As a homeowner, I have the right to know which rule I'm supposedly violating. Otherwise, this is arbitrary, and arbitrary enforcement can be challenged." I let that line linger. In my role as a judge, I recognized the spark of fear that suddenly flickered in their eyes. Arbitrary enforcement is a legal landmine. They knew it, too. They exchanged uncertain glances. At this point, I could have pulled the ultimate trump card, revealing that I was the judge on their upcoming lawsuit. But something held me back. Maybe it was a sense of timing or a desire to watch them trap themselves further. If they pushed for eviction, I'd have even more to bring to light in the courtroom. I could almost feel the tension thickening as the board realized I wasn't just a hapless new resident. I knew my rights, and I wasn't afraid to assert them. Bernice shuffled her papers. We'll take your concerns under advisement. For now, the board will table the eviction vote, pending a review of the guidelines. If we find that you are indeed in violation, we will reconvene and determine the appropriate action. Her statement was a face-saving move. They didn't want to appear incompetent in front of the community. Without a shred of documented proof, they couldn't in good faith push forward an eviction. Not yet. With that, I returned to my seat. The meeting droned on for another half hour, but the tension never eased. After adjournment, I stood to leave. Several neighbors gave me nods of support. Ellen approached me, eyes gleaming. Thank you. It's about time someone stood up to them with actual proof. Walking home that evening, the moon overhead, I felt invigorated. I had forced a delay in their attempts to oust me, but I also knew the board wouldn't back down so easily. With an impending lawsuit and their self-righteous zeal, they'd likely return with a more cunning plan. 2 days later, I received another letter, this time from a law firm representing the HOA. They requested a meeting to discuss a settlement of my alleged violations. In other words, they wanted me to quietly pay a fine and remove the flowers, no questions asked, to avoid eviction. Then when I realized just how deep this might go, they probably used the same tactic on unsuspecting residents: threaten, intimidate, then settle for a tidy sum. It was a racket, and it was about to blow wide open in court, where I would be wearing the robe and controlling the gavel. I penned a polite response to their counsel, stating I looked forward to clarifying my rights and expected documentation of every alleged violation and the exact rules they claimed I was breaking. The letter was short, formal, and ended with a crisp, "Thank you for your prompt attention." That weekend, I tidied my daisies, watered the garden, and even planted a few more. With every new bloom, I found satisfaction in standing my ground. Deep down, I hoped the other residents saw that symbol of resistance blossoming right there in the front yard of 147 Elm Willow. Yet I knew the real showdown was just around the corner. In less than 2 weeks, the same faces that tried to strong-arm me out of my own home would appear in my courtroom, pleading their case as defendants in a lawsuit that could dismantle their authority. I almost felt sorry for them. Almost. Because soon enough, they discovered that the very man they were bullying held their legal fate in his hands. The big day arrived sooner than I expected. The courthouse was buzzing as usual, but I sensed an undercurrent of tension that morning. People in suits hustled through the corridors, clutching thick case files. My own mind whirled with the knowledge that the Willowcrest Estates HOA would soon walk into courtroom 4B, prepared to face multiple complaints, never guessing that the homeowner they'd been harassing stood at the bench, robed and ready. I did my routine check-in with my clerk, who informed me that the plaintiffs and defendants had arrived. I peered through the window on my chamber door and spotted Graham and Marjorie, accompanied by their attorney. Bernice was nowhere in sight. Perhaps she was on her way. My stomach twisted slightly with apprehension. Ethically, I was supposed to declare my connection to Willowcrest, but I had to handle this carefully. At 9 a.m. sharp, I took my seat behind a bench. My clerk called the case: Residents of Willowcrest Estates versus Willowcrest Estates Homeowners Association. The plaintiffs were a group of 6 individuals, led by an older gentleman named Richard Clark. They sat on one side, their attorney looking stoic and confident. On the other side, Graham, Marjorie, and the HOA's counsel shuffled papers nervously. Bernice had still not arrived. The moment I announced my name, the defendants stiffened. My guess was they recognized it from the letters they'd been sending or from that night in the community hall. Graham blinked. Marjorie's eyes darted around. The realization struck them like a thunderbolt, painting shock across their faces. I clear my throat. Good morning. Before we begin, I have a statement to make. The tension ratcheted up another notch. I am a resident of Willowcrest Estates. I received an official notice of violation from the HOA regarding my property, which has not been fully resolved. I want to place this on the record. If either party believes this impedes my impartiality, please advise." The plaintiff's attorney stood up. "Your Honor, we have no objection. In fact, we appreciate the transparency." Then he threw a quick glance at the board's counsel, challenging them to object. The defendant's attorney hesitated, his expression caught between panic and dismay. He glanced at Graham, who looked pale. Marjorie appeared to be struggling to keep her composure. After a beat, he cleared his throat. "Your Honor, we would like a moment to confer with our clients." I granted it, retreating to my chambers for a few minutes. When I returned, the attorney rose again, face taut. "The defendants have discussed the matter, Your Honor, and request that you recuse yourself in the interest of fairness." I nodded calmly. "Understood. On what grounds specifically?" He stumbled over his words. "Why you, as a resident, could be biased against the HOA. You have a direct conflict because of your involvement in an ongoing dispute." The plaintiff's attorney countered swiftly. "Your Honor, we believe any conflict is minimal. The judge has followed proper procedure by disclosing it. If the judge recuses now, we'll face a significant delay while another judge is assigned. Meanwhile, the HOA continues to enforce policies we believe are illegal. We request that Your Honor remain, given the potential for irreparable harm if this case is delayed." I carefully weighed the arguments. In truth, I had hoped the defendants would challenge me. A recusal could have been a neat way for them to avoid the embarrassment of me knowing firsthand how their so-called rules were enforced. But I also knew the plaintiffs had a valid point. The case needed to be heard promptly. Delays could harm residents struggling under unfair fines. I clear my throat. This court takes the question of impartiality seriously. After reviewing the rules of judicial conduct, I find that my personal situation, receiving a notice about daisies, does not constitute a substantial conflict of interest that would bar me from hearing this case. My ability to be impartial is not compromised solely because I live in the same neighborhood. Unless more specific evidence of bias is presented, I will remain on this case. I gaze directly at Graham and Marjorie. I assure all parties of a fair hearing. Their attorney swallowed. We accept your decision, Your Honor." And so the trial began. The plaintiff's side presented a litany of complaints, each more damning than the last. Selectively enforced fines, threats of eviction for minor code violations, intimidation campaigns, and questionable accounting practices that left the community funds drained. Emails and letters were introduced into evidence, showing how board members used arbitrary rules to punish neighbors who questioned them. When Graham and Marjorie took the stand, they tried to justify their actions as maintaining community standards. Their attorney attempted to spin the narrative that rebellious residents were trying to undermine a well-run HOA. But as the cross-examination continued, it became clear that no consistent set of guidelines existed, only the board's shifting whims. At one point, the plaintiffs presented side-by-side photographs of various houses with unapproved items, none of which were ever cited, while certain residents like Ellen were relentlessly fined. It painted a picture of blatant discrimination. Finally, I asked pointed questions from the bench, focusing on the documentation process. "Mr. Graham, can you direct me to the exact bylaw or regulation that bans white daisies, or that states a garbage bin out 5 minutes late is grounds for eviction?" I forced him to either produce evidence or admit there was none. He squirmed, then muttered something about the board having discretion. My questions were rooted in legality, not personal vendetta. Still, the board's counsel could do little to mask the gaping holes in their defense. By the end of the testimony, it seemed painfully obvious the HOA was wielding its power arbitrarily. Bernice finally arrived halfway through the proceedings, having missed the opening arguments. She slid into the seat next to Graham, her face grim. The plaintiff's attorney requested permission to call her to the stand, which I granted. Under questioning, Bernice tried to adopt a regal, distant tone, but each of her answers only confirmed the irregularities in their enforcement. She faltered when asked if residents ever received official confirmation of which rules they were violating. "We have them sign the community guidelines when they move in," she said. They should simply follow them. How can they follow guidelines? I asked calmly. That even you can't cite verbatim? Her face flushed. We send notices, she stammered. But the notices lack specifics. I pressed, as the evidence clearly shows. Her eyes flicked away, revealing the cracks in her composure. After closing statements, it took me only a brief recess to finalize my decision. Back in the courtroom, I delivered my ruling with measured authority. The plaintiffs have demonstrated that the HOA has engaged in selective and arbitrary enforcement of its rules, causing undue burdens and potential legal violations. Therefore, I find in favor of the plaintiffs. The HOA is to cease any pending eviction or fine processes related to these questionable regulations and must undergo an independent audit of its practices. Damages will be assessed in accordance with the state statutes governing HOA misconduct. An audible gasp ran through the room. Ellen clenched her fists in silent triumph. Graham's jaw dropped. Bernice paled. Marjorie stared at the floor. Their attorney looked as if he'd expected this outcome, but had been powerless to stop it. I wrapped up with a final note. Going forward, the HOA must either adopt a clear, transparent set of guidelines through a proper amendment process or face further legal action. Court is adjourned. The gavel struck. In the stunned silence that followed, I stepped off the bench and made my way out. I might have been the judge in that courtroom, but at home, I was just another resident. I had daisies to tend, after all. Weeks later, the daisies were still in bloom, their white petals a subtle reminder of how quickly even well-meaning communities can be corrupted by unchecked power. The board members were forced to step down, replaced in a special election by a new team promising transparency. Ellen finally placed her garden gnome outside again. She even added a second one. And for the first time since I moved into Willowcrest Estates, I felt truly at home. Now and then, I catch a glimpse of Marjorie peering nervously at my yard as she drove past. Graham moved away under the cloud of scandal. Bernice vanished from public life. The new board tried to make amends, sending a letter of apology for the misunderstanding about my daisies. They invited me to join the new leadership committee, but I politely declined. A judge's place is separate from these entanglements. Although I was proud the community had finally turned a page toward fairness and reason. In the end, the eviction threat that once loomed so large turned out to be a hollow gesture. The real power belonged not to a small group of petty bureaucrats, but to the collective will of the residents, and, when it came down to it, to the impartial hand of the law. And that, at last, restored the peaceful spirit that Willowcrest Estates' many winding paths and ancient willow trees had always promised. The end.